Good morning. We'll go ahead and get started. We ran out of time yesterday morning on Senate Bill 196. Senate Bill 196 is brought to us by Senator Jackson. Senator Jackson, good morning and welcome. My own characterization of Senate Bill 196 is that it's certainly not a controversial bill. As is habit, unfortunately, late in the session, it has ended up being a vehicle for a couple more what I consider to be not controversial measures. Senator Jackson has been kind enough and gracious enough to allow members of the committee to hitch a ride on 196. That being said, there are varying subject matters on the bill. It is not a Christmas tree, and it is certainly not a controversial one. I consider it a sapling, and again, that's just my own characterization of it, and and certainly not a controversial one again. That being said, Chuck Spahos is the Solicitor General of Henry County. He's been kind enough to walk the committee through the different sections of the bill. Not a long bill, but I think it's important, given the fact that we have different subject matter on it, that committee is just comfortable in its understanding of what each section does. Again, not extensive, but I think it's more of a due diligence exercise. Mr. Spahos, thank you for your assistance.
Yes, Mr. Chairman. Thank you. Quickly to go through just what it does, because each section is a little different. Perhaps it's better to start with Section 3 to make Section 1 understandable. So when you go to Section 3, we're dealing with language that got placed in the driving with suspended license statute last year. Remember, that was in the midst of enhancing punishment for people who were driving without license, repeatedly driving without license. There was a belief that there needed to be some language to protect people that could get valid driver's license. It got put in two places, and what we're fixing in Section 3, currently that language, though it was intended to protect a certain class, it has ended up protecting anybody with a suspended license. So what we've done is we have just returned the driving with suspended license statute back to the position it was in before last year's change. If you go back to Section 1, we have taken the language that we pulled out of Section 3 and placed it back in Section 1 in the driving without a license statute, which protects the class of people that was the intent of the legislation last year.
Let me interrupt you one second. Mary Lou Morris, our counsel, has placed a section-by-section summary, which I think will also be helpful to members just to make sure we're all following along. Thank you. I apologize for interrupting.
That's fine. So that's what Section 1 does, is it takes the language that we've pulled out of Section 3 and puts it in the proper place in the code to protect the class of people that we were after. Section 2, which is part of the original bill, simply provides for a suspension of driver's license for a second conviction within 5 years of running over a pedestrian, basically. And it is a 30-day suspension, and it lays out the fees and fines or what have you to get it back after that period of time. That is what Section 2 does. We've already covered Section 3. Section 4, the beginning of it looks like we've inserted language at 76 to 80, but that's really just relocating that language from the bottom of the code section. The gist of what Section 4 does is it provides for a punishment for striking a pedestrian and what have you. For a second and 5, it creates a real misdemeanor sentence. And as we discussed yesterday, it says not less than 10, not more than 12 months. Keeping in mind that 10 days is like any other place in the code. Because this code section doesn't say it can't be suspended or probated, it can be suspended or probated. That's what Section 4 does. Again, at the end of Section 4, what's struck is actually reinserted at the top. Section 5 takes the pedestrian definition and broadens it. It makes clear what a pedestrian is. Now, keep in mind, this code section already exists about where people are supposed to walk, if there's sidewalks and that kind of thing. We're not changing any of that. We're clarifying, or this bill clarifies who is a pedestrian. And then, of course, Section 6 is the effective date. So I'll be glad to field any questions, Mr. Chairman.
Mr. Levitas, you want to talk about your portion in Section 6?
Sure.
As I understand it to be in Section 6?
Yep.
Okay. Oh.
Section 6 actually is a bill that we passed unanimously out of this committee and just couldn't make it out of rules. It's, I think, 4 words in here, and all it is adding $7 to the DUI fee for schools. That's a straight pass-through that goes to that goes to Department of Driver Services, and a third of it then is passed on to DHR for the implementation of their regulations in House Bill 336 that we passed last year. DHR has claimed that there is a $500,000 hole they're trying to patch, and this is intended to do it in an off-budget way. In other words, it was revenue neutral from the state's perspective. And that's all it does.
Thank you. Questions for Mr. Spehouse or Mr. Levitas? Ms. Benfield.
Thank you. Just a quick question for Representative Levitas on page 6. If you could just remind me, I remember there was discussion about adding different fees onto that bill.
There was, and I hope we'll do that in the off session. We just did not have enough time to get to all that. There was talking about increasing the book fees and then increasing the school fees. None of that is part of this bill, though.
If I may ask one more question, on page 6, line 168, you changed that $15 to $22.
It's actually not a change. What happens
Okay.
is part of the school fee is then taken, and there's an administrative fee that's taken out of that school fee. So, and what they're doing, since they're increasing the school fee, they're now increasing the amount of administrative fee that's taken out of that. So it's a straight pass-through on to DHR.
Thank you.
Mr. Setzler.
Hey, Mr. Chairman, to Mr. Spehouse on the second offense in 5 issue of hitting a pedestrian. What would the I think I'm getting more comfortable with that. I just was concerned about the step we're taking. What would if there is if the set of circumstances was such that the second offense was, if the person was not that heavily injured and there was some plea agreement, would they plea to reckless driving? What would the next step be from them? If someone, let's say a prosecutor didn't want to have the driver have a misdemeanor rap on their record, but the facts of the case were such that the person was hit, what arrangements could be made with respect to, again, if the person's not that seriously injured or there's some in the interplay, something other than a misdemeanor seemed appropriate, what remedies would be available to the prosecution?
I think I understand what you're asking me. If I were to evaluate a case and determine that, you know, the pedestrian and the driver were equally kind of liable for the injury, if that's the kind of thing you're talking about, certainly you could find another charge. I mean, you could even arguably put it through a pretrial intervention program and withhold adjudication. I mean, there's several different remedies you could do. This, like I said, would only come into play when you had a second and 5 injuries. So you've already had them run over a pedestrian one time, and then we're back on a second and subsequent. I'm having a hard time even. I can't think of any time in my life I've ever prosecuted something like that. But I mean, I'm open to.
And again, if they're driving recklessly and they're running over pedestrians, then this certainly ought to apply. There's
Right.
no doubt about that. I
Yes,
just
sir.
want to make sure that if there's there's some relief valves, if the facts in question are such that it makes sense to do something.
You could let them
else.
plead a failure to maintain lane.
Any further questions from members of the committee? Seeing none, what's the committee's pleasure? Move to pass by Mr. Setzler, second by Mr. Ramsey. Are there any amendments? Mr. Franklin.
Thank you, Mr. Chairman. I don't have an amendment, but due to the fact that, as you had even mentioned, that we've got several different subject matters on here, I feel uncomfortable giving a yes vote due to the multi-subject matter. I just wanted that on the record.
I respect that. I really do. I do respect that. Which really goes somewhat to the conversation we had on the floor yesterday. I see it. I personally see it as being first and foremost non-controversial, administrative. It's all tied up in Title 40, having to do with driving and various offenses that may occur involved with that. Definitions of pedestrian, of course, and then the fee issue having to do with the DUI felony statute that we went ahead and passed last year. So I understand that. I respect it. I'm personally comfortable if we were talking about anything controversial. Candidly, we just wouldn't be having this conversation, candidly. But I appreciate where the gentleman's going.
Thank you.
Yes, sir. We have a motion. We have a second. Were there any amendments? Seeing none, any further discussion on the gentleman's motion of passage of Senate Bill 196 by substitute LC 293866S. All in favor, please signify by raising your hand. Opposed? And the motion is adopted. Thank you, Mr. Speyhouse. Appreciate your help very much. Senator Jackson, thank you.
Thank you, Mr. Chairman.
Yes, sir.
Before I go, your subcommittee was as nice a group of people as I've ever seen assembled at a table.
Thank you.
I appreciate what you did. I'd like to get my good friend over here, Mr. Willis, to handle this if I get it out of room.
Don't tell them what I did to your kidnapping bill.
That was nice. Senate Bill 82, Chairwoman Unterman. Good morning and welcome back.
Good morning, Mr. Chairman and members of the committee. I feel like I'm an honorary member of your committee.
Indeed you are.
I've been here every day. I think I missed one day. Mr. Chairman, I bring before you Senate Bill 82 as a substitute that passed the Senate. It did pass the Senate 50 yea votes and 5 no votes, and the committee vote in regulated industries was 8-1 in the Senate. So it comes with a pretty good recommendation.
Let me just offer to members of the committee, in case they're unaware, of course, this committee considered House Bill 177, which is very similar, if not outright the same subject matter. I don't know if they're quite companion bills, but certainly focus on the same subject matter. 177 got caught up in rules late with some issues. This bill, I know, has been the vehicle for that continued conversation, and that's where we are right now, just for procedural purposes for members of the committee.
Okay.
Thank you. Please continue.
And Mr. Chairman, I wanted to introduce Kevin Carton, who's here. I cannot write with my right hand, and he's taking notes for me, if that's okay.
Absolutely.
Okay. I just wanted to make sure.
Sure.
And what I was going to do was go over kind of the background of what we did in the Senate, and I didn't know if you wanted me to go over Senate Bill 82 line by line. Since there is a substitute, I don't want to waste time.
Will you be speaking to the substitute?
Yes, I was, but
Okay.
if you want me to, no, I'm not going to speak to the substitute because I just saw it 5 minutes ago.
I see. I know Mr. Williams had been
Right,
working on the issue.
Right, I got it at 8:30 this morning.
Okay. Would it be constructive for Mr. Williams to join you at the table? So you,
Yeah, that'd be great.
okay, thank you. Thank
That'd
you
be
for
great.
allowing him to do that.
Great. And I could speak for 2 hours, and I have testified for probably about 4 or 5 hours in committee in the Senate on this particular bill, so I'm going to try to be brief, and y'all ask me questions, and maybe that'll cover the subject matter. What I'd first like to show you is on your table you should have a packet with that orange cover on it. I wanted to show you the coalition that has been working on this since June of last year, and it's the major trade organizations that lobby here at the Capitol, including the GMA and ACCG, the Apartment Association, Television, City of Atlanta, Agribusiness, Automobile Dealers, Apartments, Beer Wholesalers, the Georgia Chamber of Commerce, Railroad, Power Companies, Cementarians, the Home Builders Association, all of the utilities, and all of the EMCs, and I am grateful. I have had a terrible session, and if it had not been for this coalition, I would not be able to sit here today. I believe on your packet you have the next thing is from the FBI and a printout of some of the headlines from the FBI. There's some articles from the Atlanta Journal-Constitution talking about cemeteries. And this is what I talked about in the committee and on the Senate floor, was it's a shame that we have to put video cameras up in cemeteries and have to have patrol cars in cemeteries protecting grave sites and basically dead people. And that's what our culture has come to. The average cost of a vase in a cemetery, I think, is $350 to $400, and they're taken off. They literally pick up the bronze headstones that are not headstones, but the placards that are in the ground and steal them. One of the things that happened in my particular district, and there's an article in here about one of these major big parks in Gwinnett County. George Pierce Park, where the kids showed up to play ball and they couldn't turn the lights on, these big, huge football lights, because the wiring had been stolen out of the ground. And going on in here, up in Monroe in Walton County, we had a gentleman who tried to climb up a pole and he was electrocuted. The utility companies have one of their main fears is their utility workers in these substations walking into a substation and not knowing in the middle of the night that some of the wiring has been stolen and one of their utility workers being harmed. I included in here from the metal theft claims from the insurance industry, the National Insurance Crime Bureau, that shows that the city of Atlanta is number 5 in the nation with claims, and that Georgia is number 3 in the nation. And I think that's also a shame that we have that ranking as one of the most prevalent places to have metal theft. A couple of weeks ago, I attended down at the depot the State Farm Day, and they told me that Georgia and South Carolina, at the height of the copper prices, that they were averaging 10 claims a day in 2 states, and that they literally had to hire more claims adjusters to be able to go out. I think one of the most egregious things that I found out in doing the research on this topic is this sheet of paper right here that says Core Coppers, the best little core house in Georgia. This was found down in McDonough, down south of Atlanta, and these flyers were in pink. They were printed in pink, just like I printed that one in orange. And they were posted on gas pumps when you went to get your gas, and they were posted on the convenience store doors. And what is so amazing to me is if you look at the prices on here and what they get for stolen products. The other thing that is amazing to me is that basically you go out and steal your product, and then you call Steve or Corey, and they'll come pick up your product wherever they want to meet you, whether it's at the 4-way stop sign or meet you at your house. And one of the things that got me started on this was where it says aluminum rims. I had a constituent where his aluminum rims were stolen. They were $120 rims, and 4 of them, and they got $11 on here to get those rims. The other thing that's interesting to me is these catalytic converters. They don't have the price of catalytic converters on here, but they got a picture of it, meaning that if you go steal those catalytic converters, and they get $35 to $40 a piece from brand new cars, where they go to these automobile dealerships and will take like 20 off of brand new cars at a time, and then they take them and recycle them. The problem is you can't go and put that catalytic converter back on the car. It's very, very expensive, and the automobile dealers are here. We work very conscientiously trying to resolve and come to a compromise on this particular bill. We started out stringent, and we compromised 12 times in negotiations, and I went to the extent, and this is in your packet too, where I had each side fill out a form whether they were for or against Senate Bill 82, and that's included in your form. And Brian Johnson is here from Senate Research, and he did an analysis, a spreadsheet, and that's in your packet, of the point system of what was most egregious to those against Senate Bill 82 and what was most favorable for Senate Bill 82, and that should be in your packet.
Madam Chair, may I ask this?
Mm-hmm.
My sense of it is that that a lot of the same conversations that were occurring with Senate Bill 82 on the Senate side were many of the same conversations that were occurring.
So you want me to skip over all
No,
these?
no, I just on 177.
Mm-hmm.
My understanding is that Representative Williams has been in contact with the interested parties,
Yes, he has.
and of course with our leadership as well as our
Mm-hmm.
our point person on
Mm-hmm.
the issue.
Mm-hmm.
For purposes of 82, potentially going forward,
Mm-hmm.
my sense is that what we're looking at here, at least that is my understanding, subject
Mhm.
to being educated otherwise by
Mhm.
by you, Mr. Williams, and interested parties, is that
Mhm.
we may have an agreement, or the latest substitute we have may represent the best agreement that's possible under the
Right.
circumstances.
Right.
That being the case, and Mr. Williams having had those latest and greatest conversations
Mhm.
on our side, would
Mhm.
you allow Representative Williams to talk to the substitute and the changes that were made in this substitute to address some of those concerns that go back to his own bill, which is part and parcel of your bill. Would that be all right?
Yeah, that's fine. I'm not sure that he has all the background. I included it in your packet. If I could just show you one thing.
Sure.
This is the scrap specification circular that is used as the footprint for Senate Bill 82 that shows the description of the metals, and that's industry standards, and that's why it's included in that bill. And the other thing I wanted to give you was the research. We did all the research on all the other states surrounding Georgia.
Thank you.
And an analysis of it, and found that Georgia is the most lenient, and that's why we are the dumping grounds for stolen products.
Thank you, Madam Chair. Representative Williams, do you want to speak? I think maybe the most practical course of action may be for you to go ahead and speak to the substitute that, just to be transparent about it, that Representative Williams has been attempting to negotiate between interested parties and, frankly, members of the committee as well as the leadership in the hopes, anyway, of striking a balance. Can you speak to where we, and I know this committee has examined your bill extensively prior to day 30, if you could go ahead and walk the committee through where changes were as compared to where we were before on 177, that might be the best for clarification and moving forward.
Very good. Thank you, Mr. Chairman. I don't know if I'm on. Okay. Working off of LC 3709228 ERS.
0928 ERS.
Since my last appearance here, there's no changes on page 1, so you can go ahead and turn over to page 2. In section 2, we have taken out, and I can't remember the exact wording, but we had where you took a picture of the materials. That sentence is gone, and that's the only change on page 2. You'll if you have your old copy, you would have seen where that was, but it's no longer there. At the top of page 3, we've taken out all of the threshold language about check writing that we had so much discussion about in a previous committee meeting, and added a 24-hour waiting period for cash purchases. So there's no threshold language up to 500, below 100 like we had before. We just have a 24-hour waiting period on cash purchases, and we have added catalytic converters in that section. And then in section 4, the last time we met, we were at 1 to 10. That is back to 1 to 5 on the last line 76.
Question. I'm sorry.
That's it. Those are the
questions for the author or for Representative Williams, Mr. Setzler.
Representative Williams or Senator Underman, could you just explain for me, just so I have a better sort of intuitive feel, lines 58 through 65, the pay provisions dealing with cash payments and checks. There's a lot of code references and section cross references. Could you just kind of explain to me in straight English what that does?
We had a threshold, and the figure went up and down through our discussions through subcommittee from 100 to 500. After meeting with leadership on our side of the Capitol, it was a legal tender issue with some of the leadership, and so we just decided that money's good, whether it's cash or check. But the folks that we're after are those wanting the quick buck, and we felt that this was a good compromise to put 24 hours in there and slow some of this down.
So if they're getting to get cash, you got to wait 24 hours to get it.
Exactly.
If you can accept a check for any amount of money, you can get it, and you can drop the metal off, take your check, and walk out.
The recycler can write a check for any amount.
Okay, so it's permissive, and there's no. Okay.
Mr. Ramsey.
I just want to, at the appropriate time, I do want to be recognized for a motion, but I also just want to ask a couple questions. Just make a quick point. I want to thank Senator Underman for all of her work on this. Last summer, Representative Williams and I, in 1 week's time, I had a couple of high-profile metal thefts back in my district. Representative Williams, the same week, had a couple of his rental houses victimized, and we had a conversation. We said, we need to look at doing something about this. And we called a couple of the interest holders on this list, and they said, "You need to call Senator Underman. She's neck deep in it already." And we did, and it's been a real pleasure working with Senator Underman throughout that process. She has a real passion, and we're here today because of the work she's done. And I think you raised a very good point. I didn't want it to be lost on the subcommittee. You said that we have, based on analysis, we have the laxest metal theft laws in the Southeast.
Yeah.
But I think that's compounded by the fact, and tell me if I'm off base on this, but it's my understanding that we are the only state in the Southeast that preempts local governments from adding additional restrictions. So you kind of have the double whammy,
Right.
in that you have a lax state law, and local governments, unlike all the states around us, are preempted from providing for additional regulation and addressing the problem on a community-by-community basis. So I just wanted to kind of clarify that point. And again, Mr. Chairman, at the appropriate time, I'd like to be recognized for a motion.
Yes, sir. Ms. Benfield.
Thank you. I just want to echo the comments of Representative Ramsey. I think y'all have both done a great job, and this was a very contentious issue. We've sat through many hours of hearings on this, and I appreciate your diligence. And I love the questionnaire and the chart. That's extremely helpful. I might use that on bills. I might steal that idea. So I'm looking over this chart, and I just have a couple of questions, and it would have been helpful if we'd had the most recent version before this, because I'm trying to remember what's in and what's out. But it looks like the most level of concern from folks opposed to the bill were the name of the photographer, and that whole photography section is out. Is that correct?
You still have to have a photocopy of the ID.
Of the ID.
But not of the product.
Not of
the product. That's what I'm referring to. That whole provision is removed, or requirement to photo. Okay. And then the other, I don't recall the beverage clause. If you could just address that. That was listed as
Right.
the second highest level of
Yes.
concern.
If I could address that.
Yeah.
The beverage clause was put in because of we wanted to make sure that people could still recycle, and we want to promote recycling in the green environment. But what came up was, in some of the original versions, we have kids who are taking cans to recyclers, like Boy Scouts, and they could not take it under some of the previous versions because we had the fingerprinting in. Fingerprinting was our number one issue, that we wanted fingerprinting because we think it's a deterrent, just like in pawn shops. It's a deterrent for a convicted felon to go in and have to fingerprint because they're scared to do it. And that was our number one concession that we took out. So the beverage came out when the fingerprinting came out.
Thank you.
Mr. Knox.
Mr. Chairman, thank you. Something that puzzles me about the bill, and I'm looking at the substitute now. I guess this is what we're talking about, right? There's a lot of information in here about how to identify what we believe may be the perpetrator of the offense. We got fingerprints. We got a photograph. Huh? Okay, forget the fingerprints. But what we're doing is we're identifying the person that we think may have stolen something. I don't see anybody here from the district attorney's office, the solicitor's office. They used to be coming to these. I guess they gave up. But, in any event, a problem I see with this is nowhere in here does it identify the materials, so that when the police show up,
Right.
2 days later or 3 days later or 2 months later, and say, okay, where's that stuff you said they brought in here that was stolen? Well, it's been shipped to Hong Kong, or it's in a pile with all the rest of the pipes. There's nothing in here to identify. You have absolutely no way for the police to connect all this information that we've gotten together on what they think is the offender, or maybe one of the offenders, because it could have been from any one of these people that have come in there and been identified as a cash seller or a check seller, either one. There's nothing in the bill to connect them to whatever it was that they brought in, that I can tell.
already in code section, they have to give a written description of the property of the bill we passed a few years ago. They have to. There's a section on their form they have to fill out. I would love to have to keep the bill moving forward. That was one of the things that we negotiated out, was taking a picture of it, because we didn't want every Boy Scout that comes up there with a sack of aluminum cans having to get his picture made. And to keep it going forward, we took that section out. But I agree with you.
There's nothing, even if you take a picture of it, there's nothing for you to go and find it again and say, yeah, here's the stuff that we took the picture of. That's the problem. And if they're going to make a case on this, they've got to be able to identify the stuff that was stolen. That's the evidence, not the fact that somebody came in here.
Well, Representative Knox, it wasn't just a picture. It was a time-stamped photograph. I mean, the original language that we have taken out as a compromise had all that on there, that the photograph would be timed and dated.
Okay, but the photograph is not very good evidence of what was stolen. I don't think you can make a felony case on a photograph of something, because it may or may not be what it's represented to be. I don't know what identifying information there'll be in there. I've seen these photographs, and the photograph is of a pile of wire, and they said, see that wire over there? I mean, this is exactly, see that wire over there? Well, that's just like the wire that we had over there on the job site. That's not helpful. You got to be able to say, this is the stuff the guy brought in, this is what they stole, and here it is. And the police got to say, okay, fine. Now we got something we can go into court with, and we can show it to the jury. We have evidence. There's some kind of a evidence that whatever it was they think was stolen, that this person stole that. And not only that, it can't just be that they stole something. It's got to be they stole that. He may have stole this other pile over here, but if we're trying to try him on this pile that he stole, it's no good. That doesn't help me. We got to be able to identify it, and I don't think there's anything in here that's doing that. When this stuff comes in, they're going to throw it all in one pile. They take a picture of it before they throw it in the pile, and then you're going to have to be able to go, this is a picture, who took it, da-da-da-da-da, all that. I mean, you're going to have to get something in here. This is not going to help them very much. You're just going to have these people making a whole bunch of records, going through all this rigmarole, and you're still not going to get a case. This is part of the problem that I've seen with the bill in the very beginning. If it works, I'm all for it. I just don't see how it's working right now. What is it that the DAs are going to be able, and the sheriffs are going to be able to get out of this, all this identification information about somebody that brought something in there? Nothing.
Representative, Mr. Chairman,
Please.
can I just say, in the substitute to Senate Bill 82, the prosecutors and the Sheriff's Association and the municipal chiefs worked on this, and in the substitute, all of that you talked about is included to prevent that. But that's been taken out.
Okay, but here's my question. Do you really want a bill? And I'm all for this if it really accomplishes what you want to accomplish. I'm just telling you, I think what's happening here is the district attorneys and the police, that's why they're not here, is they've said, oh, we can't make any cases on that bill that we passed last year, and that all these folks are on here. We passed this bill for the EMCs, including my own. We passed a bill for them, and then they came back and said, we still can't make any cases. You've got to go back to the legislature and get them to give us a strong enough law that we can make cases on. So you have, as far as making these folks compliant, and I'm all for that. The problem is it really doesn't go far enough to get done what the prosecutors are going to say. That's not going to help us make cases. It may help them get a lot of information about suspects, maybe, that they think might be involved in something or other. They give them a list of who's operating in the area. But, that's really not the recycler's job. What y'all want the recycler to do is help get these guys. And if you don't have some way of connecting what they bring in to what they're going to be charged and tried with, it's not going to work.
Ms. Abrams.
Actually, I have a separate line of questioning. On line 60, where you indicate the checks shall be payable, does this preclude electronic transfer payments, so that if these secondary recyclers have accounts with large users, they may not receive a check, they may receive electronic wire transfers to their accounts? Does this preclude that, do you believe? No. Okay, thank you.
Ms. Byrd?
I'm on the same line as Representative Knox over there. How do these requirements help catch all those people that we've already laid the laws out? Are there not laws already for this sort of stuff That's the first question. And the second question is, how does this relate to business, or what's going to happen if they are two legal businesses that are doing business with each other, transferring that sort of stuff? How does that come into this piece of legislation?
On the second question, Representative Byrd, I think we addressed in line 63 through 65, or 64 and 65. We did add that language in during subcommittee the first time to protect that.
Do you have another one?
So, Representative Williams, does that... Go ahead.
To your first question, I think that one of the key elements of this last version is the 24-hour waiting period. We don't have enough law enforcement to catch these guys. I mean, I'm a 3-time victim in 1 year, and I've tried trail cameras, the deer hunting cameras, motion lights, everything, and it's just not working. So if we can, that 24-hour waiting period, if we can catch that guy, this is the collection point. This is where people go to turn it into cash. And we started with a bill, to answer yours and Representative Knox's question, that we thought had a lot of tools in there. But as you well know with this process, as you go every step, it gets whittled and whittled. And I think the measures that are left in this bill, although I would like for there to be more, fingerprinting and other things, will help law enforcement gather information and catch some of these guys. I think Representative Collins was the first one to float the idea to me about the 24-hour waiting period. And that gets to the meth addict, the crack addict that's trying to make a quick buck. To me, that's a good a measure we've added to this bill, because it just slows the process down. If they can't come in and turn a compressor, the way I was hit was a compressor on the air conditioner. It's a $1,300 item that's got about $25 worth of copper in it. And if they can't turn that into 25 real quick and they've got to wait and come back, I think that it helps.
And I understand that, but when we come down here, we're constantly making new laws instead of implementing what we already have on the books. So I'm still trying to figure out how is this going to really catch all those people that are still out there doing the exact same thing, and we haven't prosecuted anyone.
Well, since 2007, our last attempt at this, in my county, they've tripled metal thefts. Statewide, I don't have all the figures. I'm sure Terry, for the Sheriff's Association, he may not have them with him, but I suspect that statewide they've close to doubled. And so we're trying to perfect what's already on the books and see it. I mean, we're all after the same thing. And I think this bill helps.
Representative Williams and Chairwoman Underman, thank you for your testimony. I think for purposes of time, we've gone around the table once. Let me go ahead and hear from Maria Zach on behalf of the recyclers, so that we have their perspective as well, and then we'll move as expeditiously as we can through other testimony. We may need to continue this to tomorrow morning, and we'll see how it goes.
Thank you, Mr. Chairman.
Yes, ma'am.
My name is Maria Strello-Zach, and I represent Institute of Scrap Recyclers Industries. ISRI is their acronym that you may often hear. ISRI members represent over 4,000 Georgia employees, members of our community. These businesses pay taxes and, as you know, have been intimately struck by this horrible crime. They have had a murder occur at one of their sites. They have had numerous thefts. These criminals mean business. They want to go after the metal and steel. What we have noticed in the bills, and we're very appreciative for Senator Underman and Representative Williams and Representative Ramsey and many of the others of you who came out to our facilities and took time to learn about the recyclers. They have been trying to work to help perfect this bill and are amenable to the provisions of this LC 370928 ERS with a couple of nuances that they would like to see. Number one, on line 61, I think there was just some leftover language that technically needed to be stricken. after, on line 61, after code section 10-1-351, from and through line 62, code section 10-1-351, I think was held over from the previous version. Number two, they wanted to ask Representative Byrd, to your question about B2B transactions. Lines 64 and 65 help make sure that the checks were paid to the actual business, not to the employee, because I think that was the intention previously, was to pay to the person who was showing up and showing their ID. This actually means that the check now could be paid to the business still anyway, as it should be. Like Mr. Cleveland, Cleveland Electric, and Pull Apart, and many others would like to have the checks paid to them, not their employees, because they're the ones delivering the items. Number two, they would like to have an exemption for business-to-business transactions, because those transactions are not the criminals. That's not who you're looking for. That's, you know, these are businesses like Pull Apart, Southwire, many of the other great businesses that are here in Georgia. And so they would have been affected by this if they're not excluded. Number three, I know there was a question about preemption, that we're the southern state. There are other southern states with preemption on rules, and we do have strong laws. And number four, I think that overall we were trying to keep this focused on copper, and we would like to ask that it continue to be focused on copper, and strike catalytic converters. And I would like, there's a gentleman here, Dan Sterling, who can address why this would actually have the adverse effect and drive more crime underground if we did include catalytic converters. So the recyclers are happy with the bill in this format, and where the intention is, what we would like to do is make sure catalytic converters are struck. And also I believe that Jimmy Burgess has some language that he wanted about automobiles, and I believe that that was okay with Pull Apart, and so folks were happy with that language too. So,
Are there any questions for Ms. Zach? Mr. Sessler? No? Mr. Knox?
Where do what do the EMCs? Do you know where the EMCs dispose of their scrap metal? What do they do with it?
I imagine they also come to Georgia recyclers.
Okay. What about Georgia Power, for instance?
Georgia Power is a very good client as well of the recyclers, and we work very closely with them on the metal theft alert systems that we have, that we help. And actually, Macon, Middle Georgia area is the only place in the country who actually saw a reduction in crime because of the great efforts they've done on these theft alerts. So Georgia Power works with us in what is actually legitimately recycled for them and what might be stolen at a job site.
Okay. Now, what happened to that bill we passed last year with the recyclers? Do they have any experience with that? Have they been asked to help assist in any prosecutions?
Yes, sir. And we asked that a couple of articles be handed out to you. You should have on your desk two things. One, scrap thief handed 60-year sentence in South Carolina. We love to see these articles and actions by the courts. This gentleman apparently had broken into 40 houses and stole the copper out. And so he's actually getting prosecuted, and I think that sends a strong message. But unfortunately, it's South Carolina. We're hoping the same thing happens here, and it does. When you should have another piece of paper that shows that an alert. This was an actual internal email, so it was to our coalitions, the task forces that we work with, which includes the EMCs, Georgia Power, many of our good friends in the business community and law enforcement. And these alerts that go out actually have had such a great reduction in crime, and we're able to send out information about the individual. Unfortunately, right now, recyclers can't get the names of the people who are over and over again arrested, and they have a way to know not to buy from them in their computer systems often. So they would love to have access to information that could actually help them not buy from people who are suspects or previously convicted of these crimes. What we have found from these recent arrests, and because of the communication, recyclers have been holding seminars out in the community with law enforcement to teach them about SB 203, which passed in the 2000 session, which provided the felony provision. What a lot of people don't realize is when you guys passed the felony provision, it not only made it a felony for the criminal who stole the goods if the value was assessed at $500 or more, but it added an added felony provision then for the recycler if he knowingly was purchasing these goods as well. What's fascinating, though, is that the recyclers actually took it another step without law and put together this alert system. So the issue of knowingly has just become stronger and more teeth in the law, because we send these alerts out when a theft takes place, and we let everybody know what's been stolen to the best that we can describe it. So now, if a recycler receives that and took the goods, you got them, if there's a bad apple.
Mr. Levitas.
I had a couple of questions, and I apologize if this has already been covered. I had some work I had to do upstairs.
Has preemption been covered yet? Because I know that's true in a lot of the other southern states. There's a preemption clause. I know that's been discussed, and this is either for the author or for you, or maybe both.
Yes, sir. I know that we have Steve Littleton here, who has written many of the laws across the country, and I have been told that North Carolina also has preemption, and there are other states. So a lot of people are trying to get their hands on this mess of an issue. I mean, adding more laws and having laws different per jurisdiction and even by state means that people just move and try to move their goods. Oftentimes they're never even showing up at a recycling center. People are shipping out overseas. There's so much interaction. And I have to say, I had a light bulb moment yesterday. I think we had the CEO of Newell down along with Snitzer, the two largest recyclers in the southeast United States, who came in and said, they were just chatting amongst themselves and said, have you guys been experiencing a lot of foreigners coming in and working with you for 6 months and then all of a sudden killing off a lot of your clients? They figure out your business, and then they're figuring out who your clients are, and then they know how to pay them, and now they can't even make margin. And they used to be, making a few pennies on the dollar on their transactions, and now their competition are foreign markets because the world is getting flat and we're shipping overseas, and unfortunately, China has a lot of need. So we've seen that preemption laws, by having the preemption in there, we need to be able to get a better uniform law, because as we go across the state, it's hard for utility inspectors, it's hard for law enforcement to jump from county to county. We had a recycler in East Point call the police because a guy showed up with something suspicious. He calls around, East Point police don't know anything about it, and he goes, I don't want to process this because I know it's got to be stolen. Problem is, none of the jurisdictions knew, and it was right down the street, another neighboring jurisdiction, but nobody notified anyone. So by having those different laws, it will just make it more cumbersome and difficult for prosecution.
Can I have one follow-up? And I don't intend, I know that you and the metal recyclers, and I think Representative Williams, Representative Ramsey have done a very, very, very thorough job of trying to work with all parties to come up with a bill, and there's a very delicate balance that's been struck. So this is not by way of proposing an amendment, but it is something that I've introduced and would like your feedback on it from the perspective of the recyclers. So it goes to Representative Byrd's point about having laws on the books and whether we enforce them or not. My understanding is that one of the difficulties in prosecuting these cases, or not even prosecuting, deterring the theft, is that when somebody comes up to with copper, whatever it is, and goes to the recycler, you don't have any current way of being able to pull up a record that may show a dozen misdemeanor thefts, in which case you would deter them. What the bill that I've introduced would make misdemeanor records publicly available, like felony records are publicly available currently. Would that help in terms of being able to deter thefts, so we don't even have to worry down the road about whether we prosecute them or not? Is that something that would be helpful to your industry?
We believe it would, and we actually had a bill in the Senate, Senate Bill 52, that passed unanimously out of the Senate Public Safety Committee, that would have created a registry at the cost of the thieves to put their name on just a list that was on a website that all the recyclers could go to and pull the name off, so they would know who not to buy from. Simultaneously, we had Senate Bill 53 that also passed unanimously out of public safety, and we were sad to see those bills not cross over. Senate Bill 53 actually would take away the car of the vehicle, the driver's license of the perpetrator, as well as make it a crime to advertise for the illegal purchase of metals. So those are components that would help go after the criminal, because right now the criminals aren't being prosecuted. We know even when our recyclers call and the guy gets arrested, he's back the next day.
Right, I'm actually talking to, we need to
yes, sir.
move on. Ms. Benfield.
Given the time, I'm going to waive.
Mr. Sessler.
Appropriate time, I'd like to be recognized and make a motion.
I'm going to set out a roadmap for everybody in just a moment. Mr. Ramsey, is that what you were?
Wait.
Okay.
Yes.
Ms. Travis, you had a concern or two that you wanted to bring to the committee's attention. I think this would be a good time to do it, and after you do that, I'm going to go ahead and lay out a roadmap for everybody for tomorrow.
I'm looking at 370928 ERS. With respect to Section 1, passports included. Passports don't have addresses on them, but line 18 and 19 require the address to be included. Page 2, Section 2, lines 49 and 50 requires records to be open to inspection. That's already contained in current law. In 10-1-352, says any and all records required to be maintained under Code Section 351 have to be open to inspection. With respect to Section 3 of the bill, you've got 2 subsections which have definitions. Both of those should be combined into one subsection because we do definitions in one. Ms. Strollo has already pointed out the inconsistency and problem with lines 60 through 62. Both of those refer to a definition in 6A of 351, and it's just nonsensical if you actually read what is in 351. Those were spot check issues that I see. Also, I don't know if there's any intent with respect to, now I'm flipping back to page 2 at line 35 that says a signed statement. I don't know if there's any thought process in trying to prosecute people for some kind of false statements. But you probably would need an oath if you were to do that. I don't know the author's intent on that. Those were a couple things that I noticed in reviewing the bill.
Okay. There's some additional, let me just set it out if I could, because I know, my understanding, it's never the chair's intent to go ahead and cut off anyone or anything, but my understanding is that Mr. Sterling would associate himself with the comments of Ms. Strollo-Zach, and Mr. Edwards with ACCG, Ms. Henderson with GACE, Mr. Prater, Mr. Hayden with Keystone, Mr. Woodall, Mr. Verner. My understanding is that those individuals would go ahead and associate themselves with comments that have already been made today by either the authors. Sir, you're
No, sir. On the catalytic converter issue, my company stands alone, and there's no other ASRE member. Solves that.
I appreciate the clarification on that, and that gets to my next comment. This is what there are some cleanup issues that obviously have got to occur with regard to the substitute. The plan as of this minute is we're going to come in, and I would ask the committee, we have a recess day tomorrow. We're going to make full use of it, or at least that's the intent, to come in at we're going to call it for 8:30, and let's please try to start as early as we can. We're going to proceed to a motion by Mr. Ramsey. If there is a second, we'll then go ahead and entertain amendments. I would ask for all amendments to be pre-printed and available for members in their folder, and then we'll go ahead and proceed immediately to a markup. You're Mr. Hayden, correct? Sterling, I'm sorry. I'm going to give you just a sec. Just want to lay this out, and then I'm going to recognize you. After we go ahead and we'll go ahead and proceed to that markup immediately, one way or the other. At that point, we're going to go immediately into consideration of Senate Bill 42, a substitute on Senate Bill 42. That's the public defender bill. We're going to proceed directly into that. A substitute will be emailed to members later on this afternoon for your review prior to the meeting. After that, we'll proceed on Senate Bill 157 by Senator Harp, which is the sex offender cleanup and a committee substitute there. That substitute will also be emailed to members this afternoon at the same time. We will also go ahead. We have not forgotten about the code enforcement bill. We will then consider the code enforcement bill after that. We'll see how that goes. For members, we will provide lunch tomorrow. We're going to go for as long as Mrs. Harden will allow us, and then we'll proceed, from there. We're trying to make the best use of our time that we can, but also we want to make sure that whatever substitute we do address on any bill has been fully vetted, and a markup is available. That amendments on a markup will be clear, present, and understandable, as opposed to doing it on the fly. With that, Mr. Prater, Sterling, let me ask you if you would. We have about 10 minutes. If you could take no more than just a few minutes, and please come forward and give us your perspective on the catalytic converter issue. If that matter is a subject of an amendment tomorrow, which I sense that it may be, it'll be important for members to go ahead and have a clear perspective on where you're coming from, where the author's coming from.
I appreciate that. Again, my name is Dan Sterling. I'd also be more than willing to come back tomorrow if that's a better use of everyone's time and just participate.
I think if we could hear from you today, and then the amendment will go ahead and speak for itself then.
Okay.
But thank you.
My company is Direct Metals Recycling. We're the only high-volume legal catalytic converter recycler in the state.
And if you'd like to sit down, you're more than welcome. I don't mean to make you.
Thank you.
Thank you.
There's a packet that was handed out with your materials today. It's 5 brief slides. If I could just take a moment of your time. If you flip to page 2, when I say legal, I say comply with metal theft laws, picture ID, sworn statement, get the license plate of the truck that delivers the material, get a detailed inventory of what's recycled. We pay income taxes, we pay payroll taxes, we pay unemployment, we pay workers' comp. We're on land that's zoned properly. We have 35 video cameras that capture every angle of every transaction that we make, okay? That's 40% of your market, ladies and gentlemen. The other 60% is black market. These companies like Core Copper that were talked about, they don't do any of that. They don't pay taxes. They're on land that's zoned illegally. If you require checks or waiting for 24 hours for cash, my business goes out of business instantly, and the black market doubles. And I don't think anyone sitting around the table wants that. There is no other high-volume catalytic converter recycler in the state. I do in an hour what Newell does in a week, what Schnitzer does in a month. Okay, I do 10,000 converters plus a month. That is not theft. Those are cars that die. The converters are taken off by recyclers or taken off at exhaust shops, and those converters are purchased. When over half the market is black market and pays cash instantly with no fingerprint, no driver's license, no picture, no description, no sworn statement, okay, it's hard enough for me to win the sale. When my competitors don't pay payroll taxes, don't pay unemployment, don't work on land that's zoned properly, I'm at a 30 to 40% disadvantage. Now you're telling me to ask my customers to wait 24 hours of cash or to take a check, okay? It's not going to happen. I'll be done. And your black market will double. My opponents are a little disingenuous in the information they share because no catalytic converters are dumped in Georgia because all of the smelters are in Texas, Alabama, the West Coast, China, and Russia. The catalytic converters don't come here because the laws are lax. It's platinum, palladium, and rhodium. This is like gold and silver. These are precious metals that go out to be refined. There's really no cause for adding catalytic converters to this bill, and the Senate did not pass this bill with catalytic converters on it. This is just a last-minute ad to try to slide through. And every jurisdiction in this state that's called me and asked for my help has gotten every question answered and every piece of data they wanted, regardless of whether it's in the law or not. We hold our catalytic converters on average for a week before they're sold, and if we find out there's a theft, they sit there, the police come, they give us a receipt saying they take them, they take the material, they can match the cut marks on the converters up, they bring them back when they're done. I challenge you to find anybody that's worked with direct metals recycling from law enforcement that has had any issue with us. And I reckon to say I'm the only person in the room that's gotten anyone arrested or anyone prosecuted and anyone in jail for this crime. I've gotten 2 individuals because I'm a victim of this theft as well. So what I ask you to do is make this a copper bill, create a committee on catalytic converters. I will chair it. I will co-chair it. I'll do whatever we need to do. And we can fix this problem. But number one is fix the black market. I don't know why the prosecutors don't prosecute. I don't know why the police don't arrest. But you've already got the IRS, the State of Georgia Department of Revenue, how many insurance commissions, the local police, the sheriff, you've got state police. All these laws getting broken today. And I could set up a sting operation on each of these named black market operators, and we could have him in jail by Monday. But nobody wants to do it. Instead, we want to pass a law and feel good about it.
We appreciate your testimony. We are going to go in about 5 minutes, so we're going to go ahead and adjourn the meeting right now. We appreciate your testimony.
Chairman,
yes, Madam Chair.
Could I just add
Sure.
that the Senate substitute does include automotive parts? It's on line 27 and line 28 of the substitute. So catalytic converters were included in the Senate substitute. And can I also add, I know Representative Benefield want to say something?
Well, I'll just talk to Mr. Sterling afterwards. I'm aware of the time.
Very well.
I have 2 doctor's appointments tomorrow, and I'll
Yes,
try
ma'am.
to come at 8:30, but I can only stay to 9:30.
I would offer just for you to do what's best for you.
Okay.
I think we're on autopilot at this point as far as
Okay,
the
so I
markup.
don't need to
Whatever's,
come?
I mean, members I think know
What they're gonna do.
what they're going to do and what the parameters are with regard to the markup and amendments, and then we'll
Okay.
just let the process play out.
Okay, what about the code enforcement?
That will be up tomorrow. It will be up tomorrow. I do need to go ahead and take up 42 and 157, but we will be in communication with you so that you're not missing anything.
Okay,
on
all right.
that.
Thank
Yeah,
you.
we'll be in contact.
Thank you.
Yes, ma'am. Adjourned.